Good morning, everyone. Today I'm going to be talking to you about the new Massachusetts Paid Family and Medical Leave Act. Now, the act was signed into law in June 2018. The law has two major components, contributions and benefits, but today I'm going to be talking primarily about contributions because there are some deadlines coming right up relating to contributions, whereas the benefits don't go into effect for another year and a half. So beginning in 2021, employees and some independent contractors may take up to 26 weeks of paid leave for qualifying medical or family events. Now, the benefits will be funded by a new payroll tax, and that is effective July 1st of this year. So it's about another month and a half. And employers with a workforce of 25 or more will be required to contribute to that as well. The program is administered by a new state agency that was developed for the purpose, the Department of Family and Medical Leave. The act covers just about everyone. It covers all Massachusetts employers. It covers all employees who work in Massachusetts, whether they be full-time, part-time, or seasonal. All self-employed workers are eligible to pay into the program and receive benefits if they choose. And some independent contractors are required to pay into the program, which I'll get to in a minute. Many of you have probably dealt with the FMLA, and there are similarities between the two, which I've listed here. Among those are leave is available for the same medical and family reasons. It can be continuous or it can be intermittent. And the employee needs to maintain their health insurance benefits, and they are required to be returned to their position when they return from leave. But even with those similarities, paid family leave is not just FMLA that's paid. There are significant differences, and the most important is that this program is administered by the state government, not the employer. So the employer is going to have a lot less control over the benefits, who takes leave, and when. It's also much more generous. It's a 26 weeks of paid leave per 12-month period, as opposed to 12 weeks. And that 12-month period looks forward from the first day of leave. And that's different from the FMLA in that with the FMLA, employers have a few choices about how they can calculate that 12-month period. It's also more generous in terms of what a family member is. It broadens that term such that there will be more opportunities for employees to take this leave than they would under FMLA. And employers cannot require their employees to exhaust their accrued paid leave. And I put exhaust in quotation marks here because the regulations have not yet made clear what exhaust means. Whether that means, could you require them to take all but one day of their accrued paid leave? It's not clear yet. Hopefully the final regulations, which are due out by July 1st, will make that more clear. So the first requirement for employers under the program is providing notice to your workers by June 30th of 2019. There's both a poster requirement and a written requirement. The poster is available on the DFML's website. I've also included it in your packet so you can see what it looks like. The template itself is in English, but if you have 5 or more employees who speak a language other than English, you need a translated version. The website does have about 12 languages available in a translated version. So you can print that out, laminate it, stick it on the break room wall or the cafeteria room wall or wherever your posters like this are usually kept. There's also a written notice requirement. By June 30th, you need to provide all of your workers, so employees and contractors, with a written notice of their rights and obligations under the law. Again, templates are available. on the DFML's website, and there are 12 languages available other than English. Now these, for the current employees and contractors, the template requires them to sign and acknowledge that they have received this notice on or before June 30th, 2019. So that's an important deadline, and you want to make sure you get it to them before then, so they can sign it, acknowledge that they received it, and return it to HR. Also, going forward, every employee and contractor needs to get that written notice. Now, moving to the first major aspect of the law, contributions. These are going to start on July 1st, 2019 with an initial payroll tax of 0.63%. That's up to the Social Security limit, which right now is about $133,000. The total required contribution is split up into a medical leave contribution and a family leave contribution. The medical leave portion is more. If you have less than 25 covered workers, the total required contribution can be totally come from your employees. If you have more than that, it's going to come from you as well. And that calculation, what portion needs to come from you, comes out to about half of the required contribution. So it's going to be about 0.31% of the employee's earnings is going to need to be paid by the employer. And the next slide here just breaks down that contribution for you. You can take a look at it. This chart was provided by the Department of Family and Medical Leave. Now, if you have less than 25 covered workers, that bottom line does not apply to you because the employee will be paying for all of it. So to determine how much this is going to cost you and your employees, there are 3 questions that you need to ask first. Do you have to pay a share of your employees' required contributions? Are the contractors who work for you required to contribute? And do you have to pay a share of their required contributions? And the answer to all of these depends on your workforce size, as the law refers to workforce size. And this is, because it was a regulation set forth by the state, it is unnecessarily complicated. And it is confusing, and so while I'm going to quickly go through it, I also have a couple of examples that should help explain it. First, there's a difference between your total workforce and your covered workforce. Your total workforce is every employee or contractor who works for you, and covered workforce is the amount of workers who have to pay into the program and will be eligible for benefits. Now, all W-2 employees are covered workers. They all will pay into the program. They're all eligible. Contractors are covered if they make up more than 50% of your total workforce. And if so, you're required to withhold earnings. If they are more than 50% of your workforce and you have a workforce of 25 or more, you need to also contribute on behalf of these contractors. Sorting that out, if we take the example of an employer who has 15 W-2 employees and 10 contractors working for them, and by the way, this is an average that goes back over the past calendar year from from January 2018 to December 2018. So this employer has 25 workers total, and because the contractors make up less than 50% of their workforce, only the 15 W-2 employees are covered. Now, that means that the employer is responsible for withholding each employee's total contribution from their earnings. They don't have to withhold any earnings from the contractors, and because their total workforce is because our covered workforce, is less than 25, they're not responsible for paying any portion of anybody's contribution. In the next example, the employer has 10 W-2 employees, 16 contractors for a total workforce of 26. And because the contractors make up more than 50% of the workforce, the employer needs to withhold a portion of each employee's and each contractor's contribution from their earnings. And because the covered workforce is more than 25, they need to pay a share of both the employees and the contractors' required contribution. And finally, an easier one with 5 W-2 employees, 11 contractors. There's only 16 total workers and there's 16 covered workers. So the employer has to withhold from both employees and contractors, but they're not responsible for paying any portion of that. Beginning in October 1 of 2019, these need to be remitted to the department through Mass Tax Connect, and that's going to be for the July to September quarter. And going forward, they will be remitted quarterly. Now, benefits don't come around until January 1st of 2021 for eligible covered workers. I say eligible because there is a financial eligibility test. It's a very low bar. It's the same as unemployment, so most people are going to qualify for this. Covered workers can take up to 20 weeks of paid medical leave per year, 12 weeks of family leave for a new child, 12 weeks of family leave when a family member is deployed or is about to deploy, and 26 weeks to care for a family member who was injured or became ill on active duty. Now, important to note that there's no requirement that an employee or worker has been working for you for a certain period of time, so even a very new employee can take these benefits. And the max weekly benefit, by the way, is $850. So this is just partial wage replacement. Covered workers as of July 1st, 2021 will be able to take 12 weeks per year to care for a family member who is ill. But again, each worker can only take 26 weeks per year total in aggregate. A few brief notes on when an employee takes this leave. The employer needs to continue paying health insurance and benefits. They need to restore a returning employee to same position or similar, same pay, same status, all of that. And the employee does need to give 30 days notice if it's feasible. And you can make a requirement that says an employee who's gone out on medical leave has to certify that they are fit for duty before they come back. And now we get to that portion of what happens if an employee or the state believes that an employer hasn't complied with their obligations. Now, the biggest minefield here is retaliation. We all know we can't retaliate against workers who exercise rights under, for example, FMLA. And here it's under the PFML. However, here there is a presumption of retaliation if within 6 months of the employee returning, an adverse employment action is taken against that employee. So if within 6 months of an employee returning from leave, you discipline them, you demote them, anything along those lines, you are presumed to have retaliated against them for them taking that leave. This can be overcome with clear and convincing evidence, but that is a higher standard than is required, for example, if you have an employee claim that you discriminated against them. So there's also no administrative filing, so they don't need to go to the MCAD first or the Attorney General. They can go straight to court. If an employer is found to have retaliated, in addition to being liable for back wages, emotional distress, you can also potentially be liable for triple damages, and that's at the discretion of the court. So the court gets to decide whether they think you should have to pay triple damages or not, and attorney's fees. There is also a penalty component separate from retaliation if you do not pay when you're required to contribute, and that is 0.63% of your total payroll plus paying the contributions that were owed. I'm very briefly going to mention exemptions for private plans. There is a provision of the law that provides for exemptions for employers who want to put forth their own benefit plan. However, it doesn't look that it will be very popular because your plan has to provide benefits that are equal to or more generous than the law. It has to be available to all employees, and it even has to be available to former employees for up to 26 weeks after they leave your employment. So while some employers may want to apply for an exemption if it's important to them to have great control over the process, they will be paying for all of this. So the exemption portion is not likely to be particularly popular at this stage. So we have reached next steps for the immediate future. First, if you haven't already, contact your payroll administrator immediately to make sure that they are set up to start withholdings on July 1st. And that if, as an employer, you're required to contribute to that the withholding takes your contributions into account. Also, you'll need to display and deliver notice to your employees by June 30th. You also want to add a new PFML policy to your handbooks so that expectations are clear. And you'll want to add that required written notice to your new employee orientation materials. This last slide here is just a cheat sheet of important dates and deadlines that you'll want to make sure to be aware of. Are there any questions?
So I have a Southern New Hampshire office. So we have employees that live in Massachusetts, primarily work in New Hampshire. I have employees that live in New Hampshire, primarily work in Massachusetts, and the same thing in Rhode Island, but Rhode Island has their own issue. So what do I do? Do I include them as covered employees? Do I not include them? Do I ask them if they want to be included?
At this stage, a W-2 employee, for example, in Massachusetts, is anyone who's issued a W-2 form for performing services in Massachusetts. So again, there are vagaries to that, how much services, generally primarily their services are based in Massachusetts. So even if they live somewhere else, if they're performing services in Massachusetts, primarily.
The manager lives in Massachusetts, works in Manchester. Primarily he works in Manchester.
Then no.
I know that there'll be paperwork, just like the FMLA has forms that we send to the employees and to the doctors. Do you anticipate that that's going to happen here in Massachusetts?
Actually, because this is administered by the state, the employee needs to send their paperwork, their application, their medical certification to the state, and the state will decide whether or not they get to take leave and receive benefits. Now, if an employee applies for benefits, then the employer will need to submit certain paperwork about how long the employees work there, the leave that they've taken, how much they make, that type of thing.
And with that, will we still have to send FMLA paperwork, even though it's going to kind of be moot?
There is some confusion about that right now, and I say that because the PFML is supposed to be concurrent with other leave like FMLA, like earned sick time. But because there are some different requirements for FMLA, it is possible, at least now the way the law is structured, that an employee will be eligible for this leave, but not for FMLA. So it would be very difficult for those to be concurrent if they're eligible for one but not the other. So From the way it looks now, and again, they may clear this up in the final regulations, it looks like you may need to split that paperwork, you may not. In the boy in the back?
On the workforce side, when you're calculating that, is that full-time equivalents or?
Nope, it is everyone.
Because we have some 1099s who do very little work, a few hours a year for us, but if you add them all up, it could be in numbers.
And again, as of right now, with the regulations, it is all employees. They're not making it full-time equivalents. But again, there are still questions. There will be hearings, public commentary before the final regulations, and an issue is clearing up some of that confusion with the 1099 employee only does a few things for me.